Tuesday, June 17th, 2026 at 3 o'clock p.m. This is an open meeting in which all members of the public are welcome to attend. Please note that it is being recorded and will be part of the permanent record of the town. Also note that in preparation for this meeting, we have received a voluminous information package, which I will not detail for you, but suffice to say, containing all the information that I believe that we need to handle today's proceedings. We have also conducted a site visit last Wednesday with regard to these same proceedings. My name is Dave Zamorowski, and I am the newly elected chairperson of the Board of Appeals, and I'm going to conduct these proceedings. Before I ask my fellow board members to introduce themselves, I'd like to just make one good housekeeping note. And that is, sometime around 2 weeks or so ago, I ran into a planning board member, and prior to being elected to this position, had a brief conversation with them on this subject. We did not discuss any information that is beyond the record that we've received. I was not petitioned to vote in any certain way, and I don't believe that that conversation, which lasted all of 1 or 2 minutes, has any bearing on my ability to be impartial and fair in this hearing. Having said that, this board has a long history of integrity, and I thought in the interest of maintaining that history and on the advice of counsel that I would bring that up if anyone has any questions, comments, or objections. There being no objections noted, I would ask the board members to introduce themselves, probably starting with Steve.
Steve Musica.
Steve Brohall.
Ned Simmons.
Pat Lawson. Ann Caldwell.
With that, please note that we have a quorum of the board in attendance. And please note that as an alternate board member, Ann Caldwell will not be voting today, but I have beseeched her to participate in today's meeting in order to avail ourselves of her wisdom and counsel, and she has graciously accepted. For those of you who are not used to who are used to a typical appeal of a code violation, please note that this is an administrative appeal, which I will describe in a few minutes. And as such, I intend to follow a set of meeting procedures which may be less than familiar to you. First, and forgive me for the formality, but it is important to get a lot of this information into the record. First, I'm going to read into the record the details which are important. Then I'll outline the specific procedures whereby we'll conduct this meeting. For the record, we are meeting this afternoon pursuant to Section 14 of the Town of Harpswell's Subdivision Ordinance as amended in 2021. The Board of Appeals will hear and decide an appeal where it is alleged that there is an error in a decision made by the Planning Board under the Subdivision Ordinance. That is the heart of this matter. The decision regards the lots at 19 and 8 Curtis Cove Road in Harpswell, owned by James and Sarah Merriman. The procedure for this hearing is provided by Section 2691 of Title 30-A of the Maine Revised Statutes and Section 12.3 of the Basic Land Use Ordinance as amended on March 14th, 2024. Before I move on from there, I would like to ask a question of the individual board members, and for the record, if you would individually answer this question, I would appreciate it. Does any board member know James or Sarah Merriman or have any knowledge regarding this matter, which means that you could not fairly and impartially hear the facts in the record and decide the matter based on the arguments presented at this hearing? Steve? Steve?
No.
No.
Pat?
No.
Okay. Next, I'll ask Mr. Merriman or his representative to stand up and introduce themselves, including their name, address, and position.
My name is Gerald Schofield Jr. I'm an attorney at law at Hopkinson and Abendanza. My office is at 746 High Street in Bath, Maine. I'm here on behalf of the Merrimans, who are the applicant's appellants. Kevin Clark of Sightlines is also here on their behalf. I'll address this now. The Merrimans have been fully engaged in this process throughout from day one. They planned to be here last week when the hearing was originally scheduled, but they are fishermen and they have a crew who relies upon them, and they're at a regulated industry when they can fish only on certain days. So they wanted me to apologize on their behalf for not being here. They would certainly hope that their absence is not taken in any way as disengagement in the process, as they're fully engaged, and thank the board for its time.
Speaking for the board, we are entirely sympathetic, and we hope they have a good day out fishing.
Thank you.
Next, I'd like the representative of the planning board to do the same.
Good afternoon, Mr. Chair. I'm Amy Chow, and I am representing the planning board in this matter, and I assisted the planning board in its decisions on the procedures below.
And your firm
Drummond Woodsum.
and position at that firm?
I'm an attorney.
Okay, thank you. Lastly, I'd like the counsel for the Board of Appeals to introduce himself.
Sure. My name is Michael Carey, and I'm representing the board today in this matter.
Thank you. Moving on to board procedure. Again, some of this is boilerplate. You'll have to forgive me, but it's important to get this into the record. When the Board of Appeals reviews a decision made by the Planning Board under the subdivision ordinance, the board shall hold an appellate hearing. The board shall limit its review on appeal to the record established by the Planning Board and to the arguments of the parties. The board may not accept new evidence as part of an appellate hearing. The person filing the administrative appeal, the Merrimans, have the burden of proof. In terms of conducting the meeting, the board will follow the following procedures for the conduct of the meeting. First, the owners' representatives in this case, may present written evidence from the planning board record or argument to the board. Next, the planning board representative may present written evidence from the planning board record or argument and respond to the evidence or argument presented by the owner. Next, the owner will have an opportunity to respond to the evidence or argument presented by the planning board. Please keep in mind that during these presentations, do not comment, do not ask questions. Please let them proceed in an uninterrupted fashion. If you have one of these, oh, I got to ask this question moments, please write it down. I will call on you later. You will have the chance to ask that question. Following the board, following that, board members can ask questions of the owner or the planning board representative, and I would ask that the board address their questions through the chair just to reduce any confusion. Following the board's questions, I'll open the floor for any additional comments from the members of the public in attendance, but please keep in mind the specificity of this hearing, and please keep any questions or comments that you have on point. Again, if you wish to speak, wait till you're recognized by the chair. Next, so after all that's finished, each side can then make closing remarks of not more than 2 minutes each. I beseech you, 2 minutes each. After all the arguments have been made and presented, the board will then deliberate on the issues for resolution that are before us. We intend to have a vote today, but the board will decide all appeals within 35 days, and after the close of the hearing, and issue a written notice of decision on all appeals. I expect that the notice of decision, should we have one, will be take us probably the next few days as opposed to longer. I will work with counsel on that. The chair will make evidentiary determinations as needed on the advice of the board's attorney. This is an administrative hearing and not a court proceeding or trial. Therefore, the formal rules of evidence will not apply. With that, I will ask the owner's representative to come to the podium to present their arguments.
Good afternoon. May it please the board. Again, my name is Gerald Schofield, and I'm here on behalf of the applicants, the Merrimans. We are here on the Merrimans' appeal from the Planning Board's denial of their application to amend the Tranquil Shores subdivision plan by removing lots 5 and 6 from that plan, a proposal universally supported by all of their abutters and the other subdivision members. The applicants request that this Board of Appeals reverse the Planning Board's denial, determine that the proposed amendment satisfies 30A MRS 4409, Section 9, in the Harpswell subdivision ordinance, Section 9.1, and approve the subdivision amendment as applied for. All of our written materials have been submitted to the board and are in its possession. This appeal is not about whether the Planning Board had the authority to review subdivision amendments. It does, and it did. This appeal is about whether the Planning Board may deny an otherwise compliant subdivision amendment based upon an unwritten circumvention theory that appears nowhere in the aforementioned 44099, 4407, subdivision ordinance section 812, section 91, or in the basic land use ordinance provisions cited by the Planning Board. The Planning Board found the application complete, found nearly every state statutory standard satisfied, found most local subdivision standards not applicable, and denied only because it believed that the applicants should not be allowed to receive the regulatory consequence of removing lots 5 and 6 from the subdivision. That was legal error. Maine courts review municipal land use decisions for errors of law, abuse of discretion, or findings unsupported by substantial evidence in the record. Maine courts interpret ordinances according to their plain meaning and construe them reasonably in light of their text, structure, purpose, and objectives. The central issue here is legal. The question is not whether the Planning Board preferred a different policy outcome. The question is whether the ordinance text and the statute authorized denial on the ground that the Planning Board used, and I would posit to you that they do not. The Planning Board found my client's application complete by a 5-0 vote. The issue on appeal is clear, as the Planning Board found that the application satisfied state statutory review standards 1 through 8 and 10 through 21 of section 4404, only failing item 9, which was conformity with local ordinances and plans, and only found that local subdivision standard section 9.1 was not met, which is also conformance. So our appeal here before you today, in our view, is narrow. The Planning Board didn't deny the application because of traffic, because of stormwater, sewage, groundwater, municipal services, wetlands, erosion, public safety, or any other environmental concern. It denied only because it believed that removal of this lot from the subdivision would allow the applicants to use dimensional standards in a future potential application that are not applicable to subdivisions. Maine law expressly authorizes subdivision amendments. Under 30A MRS 4407, a municipal reviewing authority reviewing a subdivision revision must make findings on whether the proposed revision meets the specific criteria set forth in 4404. The legislator anticipated that approved subdivision plans may be revised. The statute does not say that lots can never be removed from an approved subdivision. It says that proposed revisions must be reviewed against the 4404 criteria. In the written submission that you received today from the from the town's planning board representative, it states that the Merrimans bought pursuant to a subdivision and therefore they should have known. Well, there wouldn't be statutes regarding an amendment to a subdivision. Everybody buys knowing that they're buying in a subdivision. There are specific standards that you go through in order to amend that subdivision. Harpswell Ordinance Section 812 also allows plan revisions after approval. It provides a procedure for plan revisions, and Section 9.1 requires conformity with applicable law, as it provides that all proposed developments must be in conformity with all pertinent local, state, and federal ordinances, laws, and regulations. The governing question is therefore, does the proposed amendment, as submitted, violate any applicable local, state, or federal ordinance, law, regulation, or plan? The answer to that is no. The Planning Board identified no such violation in its notice of decision, and thus the Planning Board's findings are both legal error and unsupported by any substantial record evidence. Maine case law itself supports a criteria-based review. Maine courts have described the purpose of subdivision regulation as preventing uncontrolled land development and promoting planned growth, as set forth in the Town of North Yarmouth v. Moulton at 710 A. 2nd 252. But those purposes are implemented through adopted standards, not through unwritten criteria applied by a municipal body, in this case the planning board, after the fact. In Carger v. Town of Falmouth, CUM AP 0714, the Superior Court recognized that 30A MRS 4407 and local ordinances allow amendments to approved subdivision plans, and that the planning board's task is to determine whether the amendment complies with 4404 and 4407 and applicable ordinance standards. The Carger case is directly instructive. The fact that a plan has already been approved or that lots have already been conveyed does not eliminate the ability to seek an amendment. The board must simply evaluate that amendment under the applicable criteria and those criteria only. In Jordan v. City of Ellsworth, 2003, Maine 82, the planning board recognized that it may not add unwritten criteria. The law court stated that the appellant bears the burden to prove compliance, but the board's decision must still be grounded in the ordinance's actual standards. The applicants here, the Merrimans, accept that it's their burden before the board today. But the burden on them is to satisfy the criteria actually adopted by the town and by the legislature. The applicants do not bear the burden of satisfying a new anti-circumvention criterion that appears nowhere in the ordinance, but upon which the planning board's decision was based. Turning towards the planning board's notice of decision, we have essentially 5 main arguments as to why it should be reversed. First, the planning board identified no actual violation. The planning board denied because lots 5 and 6 are currently part of an approved subdivision. Subdivision lots require 80,000 square feet per dwelling unit. Removing the lots would allow the applicants to use the 40,000 square foot standard for non-subdivision lots in a later application, which was not before the planning board, and that would allegedly circumvent the 80,000 square foot subdivision requirement. That is not and does not state a violation of state statute 44049 or local section 9.1. The question is not whether the applicants would benefit from the amendment. The question is whether the resulting lot would violate an applicable ordinance, statute, regulation, or plan. And the planning board, in its notice of decision, did not identify one. There was a critical distinction between the regulatory consequence and a regulatory violation. The planning board identified a consequence. If the lots are removed, they'll be governed by dimensional standards under the land use ordinance. But the board did not identify a violation. Section 9.1 requires conformity with law. It does not prohibit a lawful change in regulatory status. 2, the planning board added an unwritten anti-circumvention criterion that does not exist in state or local statute or ordinance. The planning board found that section 812 was not intended to allow applicants to change approved subdivision plans in a way that circumvents subdivision minimum lot requirements. The notice states, the planning board has the authority to interpret the applicable ordinances in its review of this application, including the subdivision ordinance, and finds that section 812 of the subdivision ordinance pertaining to plan revisions after approval was not intended to be used to allow applicants to make changes to previously approved subdivision plans that circumvent the minimum lot size requirements or other ordinance requirements pertaining to subdivisions. The problem with that finding is that section 812 doesn't contain that limitation anywhere within its text. Section 812 essentially says you submit your revised plan and the planning board reviews it for conformance with 4404 and the ordinance. It does not say lots may never be removed from an approved subdivision, that removed lots remain subject to subdivision dimensional standards forever, that amendments may be denied if the applicant's purpose is to obtain a more favorable dimensional standard, or that circumvention is an independent denial criterion. If the town of Harpswell wants to prohibit removal of lots from an approved subdivision, it can adopt that rule. If the town wants removed lots to remain permanently subject to subdivision dimensional standards, it can also adopt that rule. But the planning board cannot create that rule itself. and it certainly can't create it through its interpretation of Section 812 when the text does not contain it. 3, the planning board's reliance on the applicant's motive was error. It focused on the applicant's purpose of creating another house lot to accommodate a family member. The problem with that is that the possibility of future development is not a present failure of conformance with state or local statute. Neither 44049, 4407, Section 812, nor Section 91 make subjective motive an approval standard before the planning board, despite the fact that it has deference in interpreting ordinances. The approval standard is conformity with applicable ordinances and plans. Even if the board accurately characterized the applicant's purpose, motive isn't the test. The ordinance does not say that it may be denied because the applicant seeks a lawful regulatory benefit. It asks whether the application conforms to applicable law, and the Merriman's application does. Even if purpose were to be considered, the lots are in similar size, shape, and dimension to all of the lots around them. For reference, the board can simply look to tax map 14, lots 28, 30, 32, 46, 48, and 50, just to name a few. I have tax cards printed out if it pleases the board, but it's all publicly available on the town's website. The result is also consistent with the new housing density legislation pursuant to LD 1829, passed in June 17th, 2025. 4, the planning board found that the application satisfied the standards addressing the public concerns normally served by subdivision review. The planning board found no traffic problems, stormwater problems, groundwater problems, sewage problems, or other environmental issues as set forth in the other standards of 4404. So this is not a case where the planning board denied because the amendment would create an actual adverse impact. It denied simply because it disfavored the applicant's ability to use a different dimensional standard after removal from the subdivision in a potential later subsequent application to the planning board. 5, the purpose of the subdivision ordinance itself. Harpswell subdivision ordinance is intended to protect the public welfare and encourage orderly growth through clear standards. The ordinance provides, the purpose of this ordinance is to further the intent of Harpswell's comprehensive plan in protecting the safety, health, and quality of the environment, including groundwater resources and the future quality of life in the town, and to encourage use of the best planning by private developers. It also states, the ordinance is to seek and establish an orderly, equitable, and expeditious procedure for reviewing subdivision applications and to provide clear standards that encourage orderly growth in the community. The applicants do not dispute the importance of the ordinance's purpose, but the stated purpose, we would say, supports the applicants. We want an orderly review. We want an equitable process. We want clear standards for planned growth. We want to support the health, safety, and environmental protection of our community. All of those things were met. But the planning board's denial was not based upon health, safety, and environmental infrastructure. It was based upon an unwritten anti-circumvention policy. The purpose section matters. It calls for clear standards and orderly, equitable review. The applicant satisfied the standards that the planning board actually applied, except for the board's unwritten view that this type of amendment should not be allowed. That is not a clear standard. It is not a written standard. It was one that was created and misappropriately allocated in violation of law. In conclusion, for all of the above reasons, both stated before the planning board and before this board today, we respectfully request that the decision of the planning board be reversed and that the applicant's application for removal of lots 5 and 6 from the subdivision be approved, the applicants having satisfied their burden and having met all state and local statute and ordinance standards for such removal. Lastly, I want to be very clear. The planning board serves an excellent purpose and works diligently to protect the town. We feel it did so in this case. However, all boards, whether it be Harpswell's planning board or any other, are fallible. In this instance, it simply made legal error that must be so reversed here today. Thank you very much. I appreciate your attention.
Ms. Chow?
board's indulgence, I might engage in a coloring exercise. You have my letter dated today, which has some of these exhibits in smaller form, but I thought it would be helpful to all look at the same thing. Let me first start by saying that I do agree with Mr. Schofield that the issues here before this board are narrow and they are legal in nature. And I also agree with the chair that the standard of review is appellate. There is general deference given to the planning board's findings and conclusions as long as it did not commit any legal error in denying this subdivision amendment application. Now, Mr. Schofield has raised this, he characterizes the decision as being in error because there was somehow an additional anti-circumvention criterion applied by the planning board. And I would submit, if you let me go through what the planning board actually did and what the ordinance says, I believe that, Mr. Schofield is incorrect. The planning board did not apply some unwritten standard that is not in this ordinance. I would submit that the planning board certainly can, in interpreting ordinances as a whole, including the subdivision ordinance and the basic land use ordinance that applied here, as well as subdivision law, that it can look at those things as a whole and interpret certain provisions of the ordinance to not defeat the overall purpose of the ordinance. And that's, in fact, what the planning board did here. Okay, so if you'll indulge me, this is the 1988 final subdivision plan that was recorded. And if you'll let me draw, actually, no, I'm sorry, that's not it. This is what I want. The entire subdivision here is this. 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 Does everyone see that there? So this is the subdivision that was actually originally approved in 1983 by the planning board. Okay? Originally, as proposed, this was a 6-lot subdivision, lots 1 through 6, which you can see. And if you look at the exhibits in my letter, you'll see that they are clearly numbered. All right? What the applicant proposes to do is completely remove from this subdivision lots 5 and 6, which represents a little more than 5 acres from the subdivision. Okay. I will agree, and sorry about that, that.
I'm just going to move this over so you can talk while you draw.
Oh, okay. It is true that once a subdivision plan becomes final, it can be amended if you go through certain provisions. The provisions of your ordinance are section 8.12 of your subdivision ordinance, and also is 4407, section 4407 of Maine's subdivision statute. It says more or less the same thing. If you're going to revise a plan, a subdivision plan that has been previously approved and made final and recorded by the planning board, there are certain steps you have to go through. What Mr. Schofield would say is, as long as you go through those steps woodenly and don't look at overarchingly what is going on here, then you need to approve the plan amendment no matter what it is. What I would submit is that is not correct, and that you need to look at the overarching purposes of the ordinance and the operation of the ordinance, because what is at issue here is whether or not the planning board committed an error when they decided, in looking at all of those subdivision standards, there's one that's important for you to remember. Agreed that they went through traffic, they went through impacts on stormwater, all of those things that are the substantive standards, right, that a planning board looks at for subdivision, and said those are met. However, the standard that is not met is in 4404 sub 9 and section 9.1 of your subdivision ordinance, which says essentially, I'll read it, is the proposal in conformity with all pertinent local, state, and federal ordinances, laws, and regulations. And so when the planning board looked at this, there was some concern. We do have a couple planning board members here. If they wish to speak, they can, but the concern in the discussion was, if we remove these two lots from the subdivision, then they are no longer required to have the 80,000 square foot minimum lot size for subdivision lots that is in your land use ordinance. Instead, your ordinance, and Exhibit 5 in my letter shows you that if you have a non-subdivision lot, you only need 40,000 square feet of lot size per dwelling unit. Okay, so what they've essentially done is they want to, in their plan, they've made clear, I'm going to just abbreviate, instead of 2-acre zoning on a subdivision lot, which the ordinance requires, they say, we want to have 1-acre zoning. We want to develop these two parcels in a manner that is more intense than the planning board anticipated when it reviewed and approved this ordinance over 40 years ago. Okay, so under what circumstances should that be allowed is the fair question. And what Mr. Schofield is saying is, if someone buys a subdivision lot, and in reliance in that, knows that that person buys with notice of all of the various strict standards that apply to subdivision lots, right? Have to have a subdivision road, it's got to meet certain specs, got to have certain stormwater things. All of this is to allow this common scheme of development to operate environmentally safely, with respect to neighbors, and essentially as a development plan that operates as a whole. It is true that certain amendments can be made. A common amendment that you might see is a lot line adjustment, right? Or, in fact, actually, let's use what happened in 1988. So in 1983, you have it in your packet. The 1983 subdivision plan that was approved 6 lots. In 1988, they added these 2 lots here out of lot 4. So that became an 8-lot subdivision. These 2 lots, and at the time in 1988, the subdivision ordinance did say subdivision lots have to have 80,000 square feet. So when these were created and the subdivision plan amended in 1988, those lots did abide by the standards that apply to subdivision lots, as it should, and it went through the standards, okay? What the applicant is proposing here is to say this: I bought these lots in the 1980s, 40 years ago, or the successors in interest, knowing full well there's an 80,000 square foot lot, minimum lot size, applicable to both of these lots. And now I just don't feel like abiding by that standard. I'd like to remove myself from the subdivision, thereby allowing me to take advantage of a less stringent requirement for non-subdivision lots, in this case, 40,000 square feet. Okay? So although plan amendments are allowed, I would submit to you, the question before the board was, is that really in conformance with the ordinances as they act as a whole? And I would submit to you, for a lot of reasons, that there is no new anti-circumvention criteria. What really is going on here is, if you have a subdivision lot and the 80,000 square foot lot applies to you as the land use ordinance says, what is it that you need to do to remove yourself from that obligation? The ordinance is very clear about that. The ordinance says, under the basic land use ordinance, that you must seek a practical difficulties variance from the Board of Appeals, not from the planning board. This applicant did not do that. If what they want to do, which they propose to do in their subdivision amendment, they're couching it as a subdivision amendment, but what they're seeking to do, and this is the question of motives and purpose, I would submit to you, you need to look at what is the regulatory impact of what they are seeking to do. What they say they are seeking to do is take lot 5, which is 3.13 acres, divide it in 2, so that they can get 2 principal dwelling units now on lot 5, 2 separate lots, and neither of these would meet the 80,000 square foot lot requirement under the subdivision ordinance. And so if you adopt their argument, here's how the argument goes. I buy a subdivision lot. I'm in the subdivision lot for 40 years. I abide by all those rules. I decide I don't want to abide by those rules, so what do I seek to do? I seek a plan revision under Section 8.12 of the subdivision ordinance, and I say, look at all the criteria I meet, and here's the important point. Once the lot is removed from the subdivision, guess what? I'm not a subdivision lot anymore, and I would then be in conformity with that ordinance. I would submit to you that's exactly what the ordinance is not intended to do, nor does it do that. So the violation of 44049 and Section 9.1, meaning the planning board's decision that we're concerned about the idea that a subdivision lot owner can simply come in and use the plan revision section of 8.12 as a tool to evade subdivision review and approval, which is exactly was the impact here. And I want to be clear about one thing. There's no animus that the planning board thought this applicant was doing. Nothing is personal. This is really just the impact of the proposal and the proposed tool that the applicant's representatives chose to try to get this lot split. I would submit to you that the land use ordinance is very clear that the only way to do that is to get a variance from the Board of Appeals. And if you were to get a variance from the Board of Appeals, you would have to show that there's no feasible alternative for using this lot, Lot 5, other than to split it. And to not grant the variance would create significant economic injury to the owners. Furthermore, your ordinance goes on to say that when you apply the variance criteria, you should take the Board of Appeals should take the strictest application, because variances should not be frequently granted. So instead, we are not before the Board of Appeals, we were before the Planning Board. The Planning Board, as you know, and I've cited this in my letter, the Planning Board cannot take a land use or dimensional standard that's in your zoning ordinance and waive it in a review of a subdivision application. Here's an example. What do I mean by that? The subdivision, the land use ordinance says, hey, for subdivision lots, you need 80,000 square feet. For non-subdivision lots, you need 40,000 square feet. Someone comes in with an application for a subdivision and says, I just want more density. You know, we have a housing crisis statewide. I acknowledge that, and I would submit to you the proper way to address that is through proper amendments of your ordinance and not through a very strained and illogical interpretation of your current ordinance. Okay? So what goes on here? What goes on here is that the Planning Board could not waive a minimum lot size requirement for a subdivision lot. The courts have said, the Maine Supreme Court in York versus Town of Ogunquit struck down a Planning Board's attempt to waive such a requirement in a land use ordinance, saying, no, you're looking at subdivision standards and subdivision review. You can't reach into the land use ordinance and waive setbacks, for example, or waive minimum lot size, or waive all of those dimensional standards that are in an ordinance. Why can't you do that? Because state law and ordinances give that sole authority to the Board of Appeals to do by variance. And so York versus Town of Ogunquit struck down the Planning Board's attempt to waive this very type of standard, minimum lot area, by calling it a waiver. And I would submit to you, if the Planning Board cannot waive those kinds of standards, as the law court has said, it should not be able to use 8.12, the plan revision section of the subdivision ordinance, to do exactly the same thing when your land use ordinance clearly says to be in legal conformity with the ordinances, to get the relief they are seeking here, they need to seek a variance. So I would submit to you that the proper interpretation is not to look at whether the resulting lot that you're trying to create is in conformity. Of course it would be. You have to look at whether the proposal, the removal itself, the use of 8.12, flies in the face of the operation of the other sections of your ordinance, which this clearly does. I wanted to make one more point that I think is helpful in state law, and it's in a footnote in my brief. And I think it stands for the proposition that you can't use this subdivision amendment 8.12 section to do an end run around a variance. You need both. And that section states that whenever the initial approval or any subsequent amendment of a subdivision is based in part on the granting of a variance from any applicable subdivision approval standard, that fact must be expressly noted on the face of the subdivision plan to be recorded in the Registry of Deeds. That's a lot of words, but all I'm saying is the state statute, the legislature recognized that once you're a subdivision lot, if you want to apply for something that gets you out of the standards that apply for subdivision lots, you need to seek a variance. And then, once you've gotten that variance, if you get it, then absolutely you need to record that as a subdivision amendment on the plan so everybody knows, the entire world knows that that was done. Notice that it didn't say you can avoid a variance and simply use the subdivision amendment process to avoid getting a variance and get it through a standard, an 8.12 process. That's essentially, oh, I did want to make one more point. Okay, this is the 2026 subdivision amendment plan. And as I understand it, the application here is to remove these two lots and join them, okay? They are saying that all they want to do is add one more buildable lot, and that impact would be minor and would meet every standard. What I would submit to you is that if the planning board were to allow these two lots to be removed as a plan amendment, they would come out of the subdivision. This one would be a 3.13 acre lot, and it would have sufficient road frontage to create not two lots, but three. Also, lot 6 down here, which actually they are not proposing to split it all here. They say, no, we just want one buildable lot. But their request is a blunt request. It's an overbroad request because it's asking also to remove lot 6. Why remove lot 6 if they're not intending to try to divide that one? If you remove lot 6, you can divide this current lot, again, in half because this is a 2-point-something acre lot. And if it now is a non-subdivision lot, you have 1 acre zoning. So what you have here is a proposal that even though the proposal on paper is to just create one lot, the impact of granting this proposal through a plan revision would be to turn 2 lots that were previously approved in a subdivision into possibly 5, which I would submit to you could have an overarching impact on neighbors, on the entire common scheme of development that was approved 40 years ago. So I'll stop, but in summary, I think it's quite clear that the planning board committed no error, that they were reasonable and appropriate in their interpretation of the ordinance, that 4407 and 8.12 should not be used as this broad overarching tool that would have the effect of being not in conformity with the other aspects of your ordinance, chiefly the variance standards and the waiver standards that planning boards are allowed to apply. Thank you.
Mr. Schofield, would you like to respond?
Yes, please. Thank you, Attorney Chow. Appreciate it. And thank you for the visual as well. The first thing that I would like to state is that there's been a lot of talk that the split of Lot 5 is before either this board or the planning board. It's not. There's no application to split Lot 5 at all. So we're not talking about that. We cannot talk about that. What we have to do is apply the ordinance as written to the request for the removal of lots 5 and 6 from the subdivision. And the standards are very clear, and they do not include any of the miscellaneous other items that were actually cited. So if we take Lot 5 out of the subdivision, it doesn't violate any applicable ordinance, subdivision, or basic land use. If Mr. Merriman then wants to apply under dimensional standards to split Lot 5, he has to go before the planning board. No doubt about it, no question about it. But that's not the question before you today. The question is, based upon the actual standards that are set forth and clear in the law, which says you have to follow those specific criteria, did he meet those? And the question has to be yes. Otherwise, there really would never be any amendments to subdivisions ever based upon what was proposed for you today. There's no need to seek a variance. We're not seeking a variance from any dimensional standard. We're seeking removal from the subdivision, and then we will not be seeking a variance after that if they do anything at all. So that's another thing that I would like to point out. We don't need a practical difficulties variance. I would argue that the case cited for York v. Town of Ogunquit, that stands for the proposition that a planning board may waive subdivision standards where authorized, but it may not waive requirements contained in a zoning ordinance. We're not asking this board to waive any requirements contained in a zoning ordinance. So the effect that was set forth, we would say, does not help the town's position, nor does it harm our position. And the planning board must still stay within their authority and apply only those standards which it must, which is 4404 and section 9.1.
Good afternoon, Kevin Clark. Been representing the Merrimans through the approval process. I just wanted to clarify the division of Lot 5. Our initial application was to remove those two lots, 5 and 6, from the subdivision. Later request of the planning board was, what was the intention for that lot afterwards? And Mr. Merriman was straightforward with what he intended to do. And the planning board asked us to show them on a plan what that would look like. And that's how that lot line came about on the plan. It was not part of our initial request. It was to provide information on what could be intended on the lot after the amendment was approved. And I'd also say that you would not be able to divide that into 5 lots because you have to calculate the net density and subtract the right-of-way out, and that would reduce the total lot, usable lot area of those 2 lots greater. So it would maybe yield 4, but then it would depend on the configuration and if you can meet lot lines that meet setbacks between buildings and those type of things. The other thing I'd just like to point out is, and it's more a statement on the ordinance than anything else, is it seems contrary and punitive to have the lots that receive a much more intensive review be required to have a larger lot size than the lots that can be created under the regular ordinance with no review. So I can, legally create 1-acre lots all over the place. They have no review. But if I'm in a subdivision and I have to meet all these other criteria, you still require us to have twice as much area. It just seems counterintuitive. Thank you.
If council okay with that?
Go ahead, John. I didn't usually get to make those decisions. I'm feeling good today.
I'll be very brief. Thank you for your indulgence. What Mr. Clark said is that the 40,000 versus 80,000 square foot minimum lot size seems counterintuitive, and that may be what I would submit to you is that the appropriate place to change that is to change that through an ordinance amendment, not through a strained interpretation of a tool that is not allowed or that shouldn't be allowed, the 8.12 plan revision. to essentially allow folks who bought into a subdivision to change their mind 40 years later and say, never mind, I don't want to be part of this subdivision, and I see some more attractive rules that apply to me if I get out of the subdivision. I'm not saying these folks are trying to do that. Again, I want to be clear. This is a policy question. It also is an interpretation question. Secondly, even though they say this is not an application for a subdivision amendment, they did submit this plan. They submitted this plan, and it says subdivision amendment for Tranquil Shores. And I believe that although Mr. Schofield says that the planning board somehow has to block their ears from any understanding of what the purpose of the request is, I would submit to you, I know of no legal authority that requires the planning board not to consider the purpose. Motive, I don't know about motive, but the purpose. What are you trying to do? So, for example, there might be, I've looked at cases that talk about an abandonment or a partial abandonment of a subdivision or a removal of a lot from a subdivision in certain circumstances. Certainly, for example, if a developer were to develop a subdivision and found that, close in time after development, that a certain lot wasn't going to be developed and that it would instead be kind of sucked back into the overall surrounding area, then maybe a removal of that lot from the subdivision would make sense. I would submit this is a very different situation because 40 years ago, these two lots were fully developed. They were already fully developed. And so I do think it's relevant to look at the purpose of why you are seeking to remove yourself from the subdivision. That's all I have. Thank you.
Okay. Mr. Schofield, I'll let you rebut that if that's your pleasure. Otherwise, we'll move on to the board's comments.
Sure. Yeah. I would just like to point out that if the town wanted to put in extra criterion on amendments, as I stated in my opening, the town can do so. And the proper place to change things is through the legislature, as Attorney Chow stated. The proper way for the town to further regulate is to amend its ordinances if it doesn't want certain things to happen or certain mechanisms to be done. But the appropriate channel to do that is not by the planning board unilaterally deciding that it's going to interpret and adopt a criteria that we don't believe is in the ordinance or the state statute. Thank you.
Thank you. With that, I will open it up to questions from the board.
I have a question, and I don't know who the appropriate person is. Thank you. Don't know who the appropriate person is to answer this. It seems to me that if one can apply to remove a property from a subdivision, after having bought in a subdivision with all of the requirements of a subdivision, is it possible then, and if that's agreed to by the planning board, then is it possible for each owner to then do that until you don't have a subdivision anymore? Or a subdivision of one, or something like that?
So I think the question is, if I can maybe rephrase that slightly, is could everyone else in this subdivision decide to do exactly the same thing, and we have a vastly multiplied lot density as a consequence, or anywhere else in town? So if this decision were not allowed to stand, what would be the precedent effect?
As you represent the town, I'll let you go.
So I believe that the interpretation, respectfully, that Mr. Schofield is adopting leads to, if you apply that same reasoning in every other case, I do believe that any subdivision lot owner could come to the planning board under 8.12 and say, I want to remove my lot from the subdivision, and once I do, I'm in conformance with the non-subdivision rules. That is the important syllogism to this argument. The atmospherics are interesting, but that is really what is being said here. that's not what 8.12 is. That's not what it says. It's not what the ordinance 9.1 says either. It says, is this proposal in conformance with the ordinances? It doesn't say, will it be in conformance if you grant what I'm asking you to do? And I think what is being asked for here is the only conformance that happens in this scenario is once you've granted the removal, which I would submit could lead to any lot owner, if that reasoning is adopted, could lead to, I can't think of other lot owners who wouldn't be in the exact same position, who wouldn't be in line before you.
Question on that. So are subdivisions supposed to go on in perpetuity?
They are until they are amended. Sometimes they are abandoned, believe it or not. And once they're abandoned, there are requirements for recording that in the registry and recording a subdivision vacation plan. I've seen those recorded in the registry. So until such time as something else happens, they do continue. And the law is supposed to allow them to be amended and potentially vacated with the recording of various plans, so everyone has notice.
I have a question. What would be required under Harpswell's ordinances to vacate or abandon a subdivision?
What would you require? I think it would probably come as a result of either the developer or someone within the subdivision saying, this is a defunct subdivision. Sometimes developers will get subdivision approval, then it turns out there's no market, and then they want to do something different and put Humpty Dumpty back together again. In that instance, they would have to come to the planning board for an 8.12 plan revision saying we're seeking to vacate the subdivision approval, and you would run through all of the same standards. And likely, since you're vacating them and it's becoming vacant land, you're not going to have intensification of use issues.
Are you saying it would be treated differently if it was developed rather than undeveloped?
Well, I think you'd have to look at the facts that are being presented. If they're seeking to vacate it, if it's developed, you can't vacate it. But if it's never been developed, then I think it is capable of being abandoned. But I want to give Mr. Schofield an opportunity.
I think I have what's a good answer, at least in my mind. Specifically to your question, Ms. Lawson, there are already other guardrails in place so that there isn't precedent. The Section 9 is only one of many standards. In fact, under 4404, it's one of 21 standards, 20 of which we met, one of which it was purported by the planning board we did not. There are many other reasons that a lot owner couldn't do the same thing, one of which would be if you're in a subdivision, you have other subdivision owners. And 1, 3, or all of them could come in and state, I'm not in favor of this, it's going to do X, X, or X. The specific lots could create stormwater, flood issues, other things, all of which we've addressed in our application, and we've met all those under standards because we talked to the other abutters within the subdivision, and they said, yep, it's okay. Because of that, not everybody on the face of the earth can do this. There's a specific set of facts and circumstances and a very specific set of standards that must be met. In this case, we just happen to meet them. So that would be my answer to that.
So another question along those lines is, in this particular appeal, we referenced motive and purpose. What if you're a subdivision landowner and you just don't want to be in the subdivision anymore? What do you do then? I don't need to give you a purpose or a motive.
Do you want my funny answer or my real one? Because
Well,
I
you
would
can
say
vote.
sell is my funny answer. My other answer would simply be if you don't want to be in the subdivision, you need to get out of it. And you can do so because you meet all of the standards as we do here today, or you can find another way. But you can't just unilaterally take it out, that's for sure.
You go to a planning board.
You would go to the planning board, that's right.
That's true that you could go to the planning board, but I would suggest that the planning board, who spends dozens of hours on lots of applications on the front end of this, going through sketch plan, preliminary plan, final plan approval, having very thoughtfully looked at every standard, to have someone come to you and say, I just don't feel like being in the subdivision. I do think you have the discretion to apply 8.12, but I do think that the planning board should interpret their ordinances to address, well, what, if the standards, oftentimes ordinances and statutes are written and they don't give every single standard for when you can give a plan revision. That's supposed to be an interpretation question. Mr. Schofield says, because it doesn't say anything, you should just do it, no matter what the impact. I would suggest to you that's not the appropriate way to look at it. That is, the appropriate way to look at it is, what's the overall ordinance scheme and purpose of all of this? Subdivision review on the front end and subdivision amendment on the tail end. And one thing I did mention is that, in my letter, is that the law court has been clear that a developer can't come in and make a series of conveyances that are kind of exempt transfers of lots that create what's called an illegal subdivision if the purpose of doing that and the intent of doing that is to avoid subdivision review under the statute. So if the statute is clear about saying, hey, you can't do things in a certain way to kind of evade review of subdivision because we think this is really important, then neither on the tail end should you allow someone who comes in and says, hey, it just says plan revision here and I can just, as long as you go through these things, no harm, no foul. I think the planning board has the discretion to determine that that's not in keeping with the ordinance and not in conformance with the ordinance.
So what's the distinction between developer and landowner? We've used developer a lot, we've used landowner a lot.
I did, and I think in this case, it's a landowner. So if a landowner says, I just don't feel like being part of the subdivision, what are the criteria? I think you need to look at the overarching purpose of having created this subdivision. Maybe this lot owner doesn't want to be part of the subdivision, but that means they don't have to pay in for the upkeep of the road. Or that means there are some other obligations that they don't feel like paying. I mean, you have to look at every case on its facts, but I would suggest that the planning board should be looking at all of the work that they conducted to approve the subdivision in the first place and not lightly allow a removal.
To what extent do you counsel that the feelings of the remainder of the subdivision are compelling with respect to this argument?
I'm glad you raised that question because I wanted to speak to the question of consent from other subdivision lot owners. I think it's relevant but not dispositive. In other words, I think even if you had everybody's consent for something that they are proposing to do, doesn't mean that the planning board should approve it. As an example, these folks have said they want to just create one lot here. As I pointed out, whether it's 5 lots or an additional number of lots, the consents they were given were consents based upon this landowner saying, this is all I plan to do today. Tomorrow, however, Lot 6, I never made any promises about what I do there. I also didn't make any promises that with Lot 5 I wouldn't try to get a third lot out of Lot 5. I am not saying this applicant is trying to do that. I am not. What I'm saying is that there are impacts of removing these lots when the planning board has already undertaken rigorous review of how these land areas should be used. And the Board of Appeals should really give pause before it says that the planning board is committing error when they are deciding that we should not undermine that review process through a backdoor plan amendment.
I don't want to belabor the point, but some of the reference material on the planning board deliberations specifically requested that the lot owner in this case, the applicant in this case, provide informed consent, in quotes or caps. Do you know if that ever occurred, and could you define precisely what informed meant in this case?
I'd like to turn this over to Margaret, the town planner, because I believe she has the documents, and maybe the applicant does as well.
Hi, I'm Margaret McIntyre, the town planner. I participated in this application from when it first came to the planning board in June of 2025 up until the final hearing, I think, April 1st of 2026. And I do, in my file here, have the informed consents. If you give me just a second to find them. All right. This one's dated January 27th, the consent, and then it's signed February 6th of 26. Hi, neighbors and fellow homeowners of Tranquil Shores subdivision. We are writing to update you and refresh your memories about our, in quote, Merriman's plans with Lot 5 of Tranquil Shores. As we have been discussing our proposal with the planning board, they have requested an updated list of signatures from you showing your approval of our plans. Our plans have changed slightly. Our plan is to still split the lot into 2 equal parcels. Our oldest daughter, Olivia, is currently living in the farmhouse with our granddaughter. They have made this their home and plan on staying there. Our other daughter, Emily, and her fiancé will be building a home on the other half where we plan to move the barn to. The barn will still be moved, but its new home will be across the street on our lot. Our hope is to help our children stay in Harpswell and close to us. We hope we can count on your continued support. And then it's signed by the homeowners in the Tranquil Shores subdivision. And I think Attorney Chow recommended that the applicant bring that to the planning board to really make sure that all of the members in the community understood what the plan was and what the implications of the plan were going to be. So the plan was to remove the lots, and the implication being that there would be an potentially increased density within the subdivision.
Thank you, Margaret.
And I do just have one other comment while I'm here, if I may.
Please.
In Pat's discussion about whether or not you can remove yourself from a subdivision, I'd just like to draw your attention to Section 3 of the subdivision ordinance. Section 3 being applicability. It says, this ordinance applies to all parcels of land proposed for subdivision in accordance with 30A MRSA 44014, as that section may be amended from time to time, or division of land within the boundaries of Harpswell previously subdivided. So in my mind, I read that as once a lot has been subdivided, it is always subject to the subdivision ordinance. I know that wasn't included in the findings by the planning board, but that's how I interpret the applicability of the subdivision ordinance. Thank you.
Thank you. Any other questions from the board?
No.
Steve?
Yeah. I'm a little confused. At one point, it was, this should have come to the Board of Appeals and not the planning board. And I'm a little confused. In what instance should this have come to the Board of Appeals?
I'll try to answer that question. The applicants have stated that their purpose is to do this. They want to divide Lot 5 in 2 to create another principal dwelling unit, another buildable lot. They're doing that on a lot right now that requires 80,000 square feet per dwelling unit. Mm-hmm. Your ordinance says that if you vary from dimensional standards, if you seek to excuse yourself from the rules on dimensional standards, including specifically lot area, you have to go to the Board of Appeals and follow each of the criteria, the standards for awarding a practical difficulties variance. That's the only way you can get relief from the dimensional standard of minimum lot size, 80,000 square feet, to apply here. So I think it's a little disingenuous for the applicant to say, we're not seeking a subdivision amendment, but we are. We're not actually seeking to have the board review this lot split or not. We just want to remove ourselves I think that that's a little bit of a crabbed reading, I think, of really what's going on here and what the planning board could review as the impact of either granting this removal request or not. So the reason I think the planning board should be upheld on its decision that removing these lots from the subdivision under 8.12 would not be in conformance with the ordinances is the practical difficulties variance standard in your ordinance that demands that you go there if that's the relief you're seeking.
Mr. Schofield, would you like to respond to that?
Yes, please. This is going to respond to both Board Member Musica's question, as well as a previous statement that my client was trying to do some type of backdooring work. I think it was qualifying the application as a backdoor application. It's not that at all. My client is following a statutorily prescribed procedure that it did not write, and it is doing so in a way that is fully and lawfully compliant with the standards that it also did not write, but they do in fact meet. So my answer would be, yes, if there were going to be a variance and it was going to stay within the subdivision, yeah, they would have to seek a variance of the 80,000 foot. They're applying to have the lot to removed from the subdivision. If the lot is removed from the subdivision, then it's subject to the land use requirements of the zone within which the lot falls. And that would be, then any application has to comply with that application before the planning board. So we don't think there's anything backdoor at all. We've been transparent. And when the town attorney asked the planning board to seek a purpose and they said, yep, show it on a plan, yep, go get stuff from your neighbors and say that they say it's okay, we did all of that. We've done nothing backdoor and we've been transparent throughout. So.
Any other questions, Ned?
Yeah, I have another question, I think related to the consent from the other owners in the subdivision, but when the subdivision was originally created, the review was also subject to the input from neighbors, and I'm wondering if that consent should extend outside the subdivision to abutters. They're going to be affected by the increased density as well. And I know they had an opportunity to weigh in at this point, but they also, had an opportunity to weigh in when the original subdivision was created, and I'm wondering if that creates some sort of an obligation to them to stick to what the plan was approved, the original approved plan was back in 1983 or 1988.
My answer to that would be that within the application that was submitted to the planning board, there was a complete list of abutters, and I believe it was attached to Sightlines materials. Any one or all of them had the full opportunity to come speak before the planning board in order to make the planning board aware of any objections that they may have related to density, traffic, or otherwise. To my knowledge, I don't believe anybody did. I was not at that hearing, though. Did anybody come in and speak against Kevin? I don't want to misspeak. No one opposed, no. And no one opposed. So to go back and get somebody in 1983, many may be deceased. I was one. I don't think that would be fully possible, but we did make every effort to talk to everybody that we could today, which is what applications call for before the planning board.
Steve?
Did all the deeds of the subdivision have restrictions or covenants in them that prevented lots from being split? And I haven't seen any of the deeds, so I can't tell you that.
I know that the Merriman's deeds were contained within the application. Any such restriction would have been part of the overall planning board decision, and they were not cited in the planning board's findings. So certainly none that would be applicable to the application before it or before this board today, in my estimation.
Just say that typically you don't tend to have anti-splitting restrictive covenants in a deed. That generally takes place within the operation of the ordinance. You can have restrictive covenants in deeds. I don't know. I don't believe any of the deeds here had anti-splitting provisions in them, but that I don't believe is dispositive. What's dispositive is you have a lot. Is it a buildable lot? You have to look at the ordinance to determine whether it's a buildable lot. And you have to look at the various approvals that were granted by the planning board if it's within a subdivision.
Would the deed contain a description of the subdivision as then configured upon which a buyer would rely? Effectively getting to the same place that Steve is describing, but not a
Yes.
specific prohibition, but a description of what that subdivision is and what the rules are that apply to it.
Yes, there would be a full sort of file of documents. And in this, originally, when I was asked to review this application, the original application by Sightlines suggested that lots 5 and 6 were never intended to be part of the subdivision. That's actually inaccurate. The note on the plan there actually referred to lots 3 and 6. I know we're beyond that, but I just wanted the board to know that there's been extensive review of a lot of deeds back into the history of this subdivision, and its meets and bounds, its boundaries, and its requirements. That's fully in the record and would be something that if a buyer wanted to buy a lot within the subdivision, they could certainly, through their due diligence, understand what requirements they had to abide by. I did want to talk about this issue just quickly. There was a question of what abutters got, and I don't want to dwell on it because, as I said, it's my opinion that the consent of abutting or other subdivision lot owners is maybe relevant but not dispositive. And if you have everybody's consent, that's fine. I don't believe that's the case. And in this case, if you think about what kind of a abutter notice applies, and someone could have come and objected, I would hesitate to say that on this application, an average abutter would understand that even though the particular plan right now is to divide this by 1, that the impact of the removal could be quite a bit more significant impact on traffic, on intensity of development, on all of those issues. So, again, I think the abutter issue is a little bit of a red herring, but I'm not sure that abutters and others in the subdivision clearly understood what could happen, not necessarily what this applicant wants to do, but what could happen by the removal of these lots.
Mike?
Attorney Chow, and could both of you speak to the road? Was the road created in the 88 subdivision? Note 8 seems like it may have been. And so what would be the effect of removing lot 5 and 6 when the road crosses 5 and 6 to get to the other lots?
Kevin just stepped out. He might be able to more accurately answer that, but I believe it's still part of the road maintenance agreement, and they would still have to pay pursuant to that. But I can't fully recall, and I don't want to misspeak.
Yeah, I don't want to misspeak either, but I'll do something like that, and Kevin can correct us. Here he is. But I do believe that the applicant presented some information saying that the other subdivision lot owners would allow them to use this road right-of-way. Kevin's here.
Mike, could you ask your question again?
Yes.
Sorry.
Thanks. I'm sorry I asked when you were out of the room.
I'm sorry.
Is it accurate to read the 88 subdivision that plan created the right-of-way? And it seemed, note 8 seemed to suggest that. And so what's the effect of removing lot 5 and 6 where the right-of-way seems to cross to get to the 6 lots beyond it? What would be the effect of removing them from the access to the road?
No effect because it's a private road and it's just a right-of-way where it crosses lots 5 and 6. And also where it continues across lot 4 and the other lots. There isn't a formal association. There was one back in the 80s and it expired, and there's never been a new association. It's always been maintained by a handshake, and somebody fixes the road and goes to the neighbors and says,
But if is there an easement?
Yes.
So
The
there,
right-of-way easement crossing the lots. And it
separate
would still-
from the subdivision plan?
Yes, it was deeded.
Thank you.
Doesn't the subdivision ordinance require a association?
Not in 1983.
Not that old. Yeah,
Yeah, the requirements for review in 1983, although there was a subdivision law at that time, were much less stringent than they would be today. You would probably show up to the planning board meeting with a one-page application, a plan, and a check, and
So there isn't one in this case.
no.
If there are no more questions from the board, I would ask council to provide their summary statements, and I will waive the 2-minute limit, given the challenging nature of this particular discussion and the complexity of it. Please don't make it more than 5 minutes, though.
Mr. Chair, I'm sorry, I should have mentioned this, but we do have some planning board members here.
Ah. Please. My apologies.
If I might, just for a moment. Good afternoon. My name is Dan Holbeck. I'm the chair of the planning board. I was involved in some of the earlier preliminary discussions, but I was not present at the meeting when the final decision was made. I just want to let you know where I was there. What I did want to do was to talk for just a minute about what we typically do with subdivision amendments. We get them all the time. We've got one coming up tonight where a subdivision amendment is going to be to place a road where there was none before. The question that I think Attorney Chow raised is, particularly in the idea of coming to the Board of Appeals for a variance, is for what purpose would I want to get out of an existing subdivision that I bought into? When I buy into this subdivision, I come in knowing that there are certain responsibilities and benefits to it. Why would I want to get out? I belong to a subdivision. I've got 2 other subdivision members here as well. And I can figure out a good reason why I would want to get out of our subdivision, which is that I would like to put out my own dock. And under our subdivision rules, you have to have a common dock. So, that would maybe be my reason for it. And there may be other reasons for it, and we can talk about the personal reasons why people do it, but the reason why the subdivisions stay the way they are is because of the benefits that accrue to the members. And that if people want to get out, there's probably a separate reason for it. Thank you.
Is there anyone else in attendance who would like to make a comment or has any questions on this matter? Okay. With that, it's time for our board deliberations. And Michael?
Were there?
Closing
Oh, I'm sorry. I'm sorry. Yeah.
I will try to honor your 2 minutes, okay? Thank you all very much for your attention. Greatly appreciate the opportunity to be here today. In summation, 4407 requires the planning board to make findings of fact related solely to the criteria of sections 4404. That statute is very clear. The standards set forth in section 4404 are also very clear. If it says that if lots removed from the subdivision and they do not violate any state local standard, the planning board can interpret ordinances, but it cannot create new standards under 4404. We believe that's what happened here today. Section 812 of the subdivision ordinance does not limit the time when one can seek to apply to amend a subdivision plan. It just needs to meet the standards that were created by the legislature and by the town itself. Section 9.1 states that if you meet section 404 and you're in conformity with all other local, state, and federal ordinance, laws, and regulations, then the application can meet that. If Lot 5 is under the subdivision, it can apply under certain other standards, but that's not what's before the planning board below. But that's in effect what the planning board decided. It decided that it was going to treat the application to remove lots 5 and 6 from the subdivision, split lot 5 at that particular moment in time, and that's not what happened. And while there's been a lot of talk about purpose, motive, and all that, it would be my position on behalf of the applicants that even if you do assume that additional criterion, the Merrimans meet the standard here. There's no danger of precedent in terms of people doing this over and over again. That's why there are 21 criteria, and that's why there are ordinance standards. This is a unicorn. My clients just happened to meet all 21 standards, and they were able to do so. And because of that, and because of the specific criteria that were required of them to make application, they deserve to have the planning board's decision reversed. And they don't deserve to be punished because they did so utilizing a process and procedure that is within the town's own ordinance and within the state's own statutes. If that's the change, that's not on the Merrimans, that's on other people. But I would respectfully submit to the board that it would be doing a great service by approving this appeal, reversing the planning board's denial of their application, and approving the split of the lots 5 and 6 from the subdivision. Thank you very much for your time and attention.
Can anyone time that? Is it 2 minutes or less? I'm going to try to beat you. Be less. Don't start my time yet. Hang on. Okay. The issue here is, as Mr. Schofield has put it, is removal of lot versus lot split, and that you're supposed to divorce yourself from the impact of the removal of the lot. In deciding whether, I think we all agree, whether if you look at 4407, if you look at 44049, I'm sorry I'm throwing all these numbers at you, but if you're looking at the portion of the ordinances that say, is this proposal in conformity with other ordinances? I would submit to you, this is not in conformity with other ordinances or state law. It's not in conformance with state law. I've cited 4406, which says, hey, if you get a variance, you need to record that in a subdivision amendment. All right? That is suggesting that you don't do an end run around the variance requirements in order to comply with the ordinance. Number two, you don't have to ignore the actual purpose of the proposed removal of the lot. As Mr. Hobeck used as a very good example, if you're in a subdivision, Harpswell's subdivision ordinance says you need to have a community dock. Why? Because the town doesn't want a proliferation of individual docks in close succession to each other along its coastline. That's a decision it has made. And if Mr. Hobeck decided, well, I just don't want to be part of this subdivision, and I don't have to tell you why, I would submit to you the planning board would be appropriate and not committing legal error in looking at the purpose or the impact, both, purpose, motive, or regulatory impact of removing that lot from the subdivision, whether Mr. Hobeck wanted to build or intended to build an individual dock or not. The impact of removing that lot from that subdivision for no particular reason stated is that that lot now can get an individual dock. This ordinance needs to be read as a whole. Ms. McIntyre has stated that the subdivision ordinance applies under applicability. Section 3 says that this applies to all subdivision lots and lots that are previously subdivided. So there has to be a darn good reason to remove a lot from a subdivision, such as a vacation or an abandonment, but not this situation. Finally, I do believe that the variance standards in your ordinance also would be flouted and circumvented if this removal request was granted, and I don't believe 8.12 was intended to be interpreted so broadly to allow or to result in the other ordinance provisions not being met, such as those variance standards. Thank you.
Thank you. Well, fellow board members, not sure the way we've traditionally gone about this, but I'd love to hear your individual thoughts and comments on this, and I think maybe I'll pick on Ned to go first to begin our thoughts.
I guess I still have some questions for our attorney, which, which I'd like to address.
Please, yeah.
So, yeah, the one that comes to mind first is the argument that the subdivision ordinance applies to previously divided lots. Would you interpret that to mean that in perpetuity, once a lot has been part of a subdivision, then it's forever subject to the subdivision rules?
Can you hear me? The planner read it as it reads, so this ordinance applies to all parcels of land that propose for subdivision in accordance with state statute 4401 sub 4, or division of land within the boundaries previously subdivided. So it does, a question that comes to my mind is whether this is more restrictive than the statute. But the planning board isn't argued that you can't amend a subdivision or remove. They're saying that this should be read to indicate the purpose, and so I think you don't have to reach the point of whether or not it's not allowed to do what they're doing, but it does say that it applies to something that was subdivided, and you can kind of read it for their purpose if you find that compelling.
Did that answer your question?
I think so, and I may be getting ahead of myself. I'm thinking about what happens down the line. You withdraw this, and you still may not be able to divide it because it's still subject to the rules. That's the way off the top of my head, the way I read this. And I think that's the way you answered it. Was that even if we withdraw, even if it was, and again, I guess that's not what's in front of us. So I guess I'll
Yeah, and I guess
drop that.
I hedged a little bit there because that hasn't been developed before us, but I do think there wasn't a suggestion by the applicant you couldn't read it as intent. How far that goes is not a question that's been developed.
I mean, I guess my impression is that this proposal is inconsistent with the overall intent and purposes of our ordinance and the state's ordinance as well. I mean, I've always, and again, this is just an assumption, but I've always assumed that a subdivision is a subdivision and it is forever. And, that in order to, and I guess Amy did point out certain circumstances, but it sounded to me like it would be possible to dissolve a subdivision, but that would more than likely happen when it hadn't been developed at all. It was abandoned. The lots haven't been developed, they haven't been sold. The developer is stuck with these divisions, and he doesn't want it anymore, and it just goes back to the way it was. That certainly makes sense to me. To apply that to a developed, to apply that to a developed subdivision, to me just seems inconsistent with what I always have understood anyway, the purpose of the subdivision ordinance to be. It was predictability and I mean, primarily predictability for the folks who are buying in and for the abutters and so on, that, we're going to subdivide this and we know what's going to be there for the next whatever, until the rules change, and, to the extent that we can, I guess the way I see it is, in order to do what the applicants are looking to do would require an ordinance change, either at the state level or the town's level.
Pat?
That's basically how I come out on this. The town has relied on the existence of these subdivisions to do its density planning, to do everything it does with regard to the planning board, and to yank out subdivision lots willy-nilly or piecemeal, I think doesn't meet the letter or the spirit of what the town's ordinances are trying to do. Now, if the entire subdivision, everybody came with a, we don't want this to be a subdivision anymore, and worked with the planning board to say, okay, what about this, what about that, et cetera, the things that are nailed down as part of subdivision planning, I'd feel differently if it was the entire parcel, the entire, what is now the subdivision. But to withdraw lot by lot is not my understanding of a subdivision.
Ann?
My take on this is that the law is extremely clear that the Planning Commission has the authority to interpret the rules of the ordinance with regard to subdivisions and zoning. And that authority for interpretation, in my mind, includes thinking about the effects of an application such as this. And that has been brought out very clearly in this hearing by a number of people. The effects being perhaps unintended consequences as a result of what seems to be a very narrow and simple application. And therefore, my feeling is that the Planning Commission, given the authority vested in it, has made the correct decision in its prior analysis.
Thank you. Steve or Steve?
Let me just ask, maybe Margaret knows the answer to this off the top of her head. If I recall in the subdivision ordinance, there's a distinction between minor and major subdivisions. And what's the number of lots in each one? So my point is, this one is probably a minor subdivision, I'm guessing. I can't remember what I read the whole subdivision ordinance, but I can't remember what the number.
This is definitely a major subdivision.
It is because
Yeah.
of,
Over 5?
is it over 5?
I think it's 5 or more.
I think
Yeah.
it's 5 or more.
I'd have to look it up to get the exact number, but it's definitely, it meets the threshold of being a major subdivision.
So
It did when it was originally approved, and it still does now.
So I guess the concern then is, so that's not, so there's what, 8 in this subdivision now? That's 8 lots? Is that what we're saying? We're 6 and now there's 8?
6,
Or there's
7,
4 and now there's 6?
10. I think there's 10 now. The subdivision went through, when the Merrimans came to the planning board for an amendment to withdraw their lots, Sightlines also brought an amendment for Larry Losi, who's another property owner within the subdivision. He owns lot 4, which was split into, Lot 4 was split into 3 lots in 2025. So there's been a recent amendment. So I think that there's 10 lots
So
currently.
this is kind of an organic subdivision that morphs in size, huh?
And the ordinance allows that to happen. Yeah.
So I guess why wouldn't the ordinance allow it to decrease in size?
To decrease? I mean, naturally, I think in my experience, subdivisions, lots can be separated and combined as long as you're meeting those density requirements. For instance, there's a lot within the Quahog Farm subdivision that was 2 lots, and then it got sold and they got combined, and they came to the planning board for an amendment, and then it got sold, and they came to the planning board to split the lots again. So the lot, and this was also, I think, done by Kevin? Yeah, but lots, the acreage doesn't change, but as long as the lots are meeting the density requirements, lots can come and go within a subdivision.
I think that's my concern is lots can come and go. Property owners come and go. Especially if you have a subdivision that is this old. So, lot to think about.
Steve?
I was privy to hear some of the comprehensive plan discussion of the housing stock and how we can increase the housing and can't, based on water and whatever. But and the perhaps the climate is right for the town to be approached to do an amendment or to the ordinances to allow a more liberal view of subdivision ordinances and lot splits. But to me, it would take an ordinance change to allow this to take place.
I mean, my own thoughts build on primarily what Ned and Ann alluded to, is that, and let me make it clear, this really, to me, is not a decision with respect to the Merrimans. This is really comes down to a policy level decision and how the law is reasonably applied in this case. And I can't help but thinking that when that subdivision was first established, certain benefits accrued to the developer in doing that. They were allowed to create a subdivision in return for certain restrictions, and it was economically advantageous for them to operate via those rules. And those rules could be relied upon, and they were relied upon. This seems to me to be, and I'll use a word that interpretively maybe is a little bit dangerous, but this represents an ability to arbitrage the system, which is I can take advantage of subdivision rules to put in an 8-lot subdivision, but later on I can confer advantages that were never contemplated to a landowner who decides to withdraw from that subdivision to create additional density. And I'm compelled by Ms. Chow's discussion of the latitude that the planning board has in considering the meta issues that are at stake here, and not just the detailed tactics, although I do appreciate the tactics. So I think personally, I think the planning board was within its rights to make the judgment that it did.
Dave?
Yeah.
Could I just, could I throw something out here? If somebody in a subdivision, could it meet the criteria, a hardship requirement to come to the Board of Appeals, could that, would that work? And I'm not talking about this case, I'm just talking about in general. Would a hardship requirement of being in a subdivision, could somebody come to the appeals board and file an appeal of they had to be removed? Is there any state statute for doing that? And this is just for my own benefit. I'm being selfish here.
I'm probably wearing the wrong hat here, so I'll try not to. But I think it's the practical difficulty variance in your basic land use ordinance, which is 14.1.4.5 is the 14.1.4.5. There are different flavors of variances allowed by statute, and then the statute enables a town to adopt an ordinance giving those flavors. There's undue hardship, there's disability variances, there are dimensional variances for single-family residences, in certain circumstances. Then the flavor that we're talking about here is the practical difficulty variance, which has certain standards that apply when someone wants to deviate from dimensional requirements, and they are very specific, like height, lot area, lot size, and some other things like that. So when you want to deviate from the applicable minimum lot area standard, you need to apply for a practical difficulty variance, and you need to meet the 6 standards in that section before the Board of Appeals can approve it, which you've dealt with. Keeping in mind that there's also a provision that requires you to be really strict when you apply those standards.
Okay, thank you very much.
I'd add one more comment with respect to the overture to perhaps relook at the ordinance governing these issues. I would urge extreme caution, because at some level, judgment has to take the place of policy. You cannot prescribe policy in such a detailed level to deal with every contemplated complexity that would exist with respect to this issue and many other issues with the ordinances.
A comment about density. It's probably for our codes guy or Margaret. What if, for example, on either of these lots in question, the property owner wanted to build additional dwelling units? Would that, assuming the setbacks and all that, there wouldn't be an issue with that, right?
We should probably kind of stay to the application here.
Well, we talked about density being an issue, right?
Right, but here you're kind of constrained not just to the application before you, but because where it comes in its appellate, we can only consider what was before the planning board, and so if we're kind of getting beyond that,
Okay.
We can discount
wait.
density as an issue then?
That may be an argument, but if the question is kind of what other options might be available, that gets into a hypothetical
Just
question.
the point was density.
Right, and you can weigh whether that's compelling as an argument, but in terms of kind of other options, that's just not something that that appeals board should do.
Michael, I think we're ready to take a vote. Would you help us with the language of a vote on this issue?
Yeah, I think it's. I mean, it would be simply a motion to either, uphold the decision of the planning board below, or to find that it was improper and should not have been denied.
I mean, I guess I would suggest that it be couched as a support of what the board did, just based on the consensus that I'm hearing here.
So that would be a motion to.
Motion to,
Motion to uphold the decision of the May 11th decision of the
Correct.
planning board to deny the application.
Yeah.
Okay, would somebody like to make that motion?
Well, I think it would be appropriate to get some help from our council on wording on that.
Okay. Michael, we'll give you a few minutes here to
Yeah.
type that out and memorialize it.
All right, so just be a motion to uphold the planning board's May 11th decision to deny the application of James and Sarah Merriman.
Okay, could
So,
Second? All in favor? Let the record note, the vote is 4-1 with, Ann is not participating in the vote. We had a quorum and a full attendance.
Steve, did you vote, were you opposed?
I'm opposed.
So in terms of next steps, I can draft up I was taking notes, as you saw, based upon the discussion of the board and the arguments. The board should meet again, I believe it's 35 days.
It's 7 days
to sign,
for the notice of decision.
7 days for the notice?
We have 7 days to file a notice of decision.
Okay. Well,
I thought it was 35 days. Okay, so 7 days.
Could,
And do,
could that be made available at the town office and we can
What?
stop in to sign, or do we have to
It's-
formally?
You have to meet.
Convene
to-
again.
You have to meet to ensure that I've memorialized your consensus accurately.
I'm Margaret McIntyre, Town Planner. Just to clarify, you have 35 days from when the appeal is filed to first hear the application.
Right.
And then once the appeal is finalized, once the decision is made, you have 7 days.
7 days.
To sign the notice of decision.
Yep, got it. Is there any way for us, there's no way for us to shortcut that with a Zoom call or any other? Okay,
Well, the only way to do it would be if the attorney is ready to draft it right here and now, and we stick around for an hour. But
do you have a preference?
I'm not sticking around.
I mean,
Michael, how
I can't
how lo-
stick around at all.
I don't want to put you under the gun, but how long will it take you to draft up something? It doesn't need to be particularly lengthy.
Well, there's the requirements to kind of have findings of fact, and so, it does, I've drafted a lot of it, a lot of those kind of generic things and not
Okay.
gotten to the specific findings.
So I
It
think
won't-
what you said is that you prefer not to be under the gun to do that tonight.
I would, potentially need 2 hours.
Okay, we're not going to wait around for 2 hours.
Right,
so
probably wouldn't be
Why
that
don't we
long.
circle back and we'll find a time where it's convenient for everybody to congregate for a few minutes and finish this.
where you heading to Haiti?
I'm not going anywhere, I'm
And
flexible.
we have, if we're finished with that, we have 2 other minor items to deal with, unrelated to this case. First is consideration of the minutes from the May 13th meeting.
I haven't seen them.
I can't hear you over here, the fan is. Thank you. Yes, we're all set.
The minutes haven't been completed yet, so I'd ask that you pass on that item, please.
Okay.
That's what this,
Okay. While we've got you up there,
Yeah.
talk to us for just a couple of minutes about this workshop, the schedule, and more importantly, what it is, who will be there, and what is the objective of this meeting.
So Ned, as the former chair, and I had discussed having a training with our town attorney to kind of just refresh the board. I think it's important, given there's some new membership, and also you guys tend to not meet very frequently, and so maybe getting just some kind of general legal counsel about notice of decisions and policies and procedures. You know, I don't know if Amy has her schedule on you, but maybe we could all pick a couple dates. I know it's summertime and everybody's probably got either visiting family or has family visiting them, or motorcycle trips across the country.
Okay.
But maybe we can do this.
I don't have my schedule with me. Could we
Yeah.
do that
Or we can do it
via
by Zoom.
email?
Zoom,
Okay.
email, yeah, we can do it.
That's terrific. Thank you
Okay.
for teeing that up. I know I will be a beneficiary
Thank you.
of that workshop.
I think we've all probably got pent-up questions from over the years.
Yeah.
Okay, and with that, Steve?
I just have a question. I think I've been around this before. Could this board make a motion and to direct to have a system to allow the signing of, with our names drawn, with the document available at the town office during office hours?
We've had conflicting advice over the years on that subject. and I
Amy,
think-
what's your opinion?
I've done that before with different boards, and
Okay, so let's put that.
that's going to be at the workshop?
Let's put that on the agenda.
Great.
You would think that in this modern world with the technology we have, that hopefully
man.
we can find an easy solution to that.
So the answer to my question is no, we can't?
Well, I'm not sure if it's no, we can't, but we can talk
Not on
about
this
it.
one, but perhaps we can find a solution. We will endeavor to find a solution going forward to make this.
Maybe
streamlined.
subsequent ones.
Yeah.
I mean, I'll tell you, historically, when I was first on the board, we didn't do notices of decision, and they pulled kind of a dirty trick on me. My first meeting as the chair, they said, "Oh, now you're going to do a notice of decision."
Great.
And for a considerable time, we were doing just that. We would have the board authorize the chair to sign it, and I would just go into the town office and do it. And then we were warned off. Then we were warned off from that.
Oh, boy.
So,
Okay.
so that's how we got to the point where we had to sign them in person in a public meeting.
With that, do we have any other business to attend to?
I don't have any,
Okay, can I have a motion to adjourn?
don't need a motion.
You don't?
No, you can just say we're adjourned.
We're adjourned.